Hi, folks. Denise Howell here. And next up is This Week in Law with my wonderful co-hosts, Emory, Roane, and Mike Keys. We're going to revisit Redigi, talk about the newly enacted DTSA and the possibly enacted Email Privacy Act. We'll talk about who the heck Satoshi is and disparaging and offensive trademarks, all next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, Mike Keys, and Emory, Roane. Episode 346, recorded May 11th, 2016 for May 20th, 2016. Red flagged as Sith. This episode of This Week in Law is brought to you by Braintree. Looking to set up payments for your business? Braintree gives your app or website a payment solution that accepts just about every payment method with one simple integration. Plus, Braintree will give you the first $50,000 in transactions fee-free. To learn more, visit braintreepayments.com/TWiL. And by TunnelBear. TunnelBear is the simple privacy app that makes it easy to browse privately and enjoy a more open internet. To learn more and get your free TunnelBear, visit trytunnelbear.com/TWiL. Hi, I'm Denise Howell, and you're joining us for This Week in Law. I'm here with my two wonderful co-hosts. Emory Roane is with us today. Hello, Emory.
Hey, Denise. Hey, chat, and hey, listeners. Thanks for having me.
Great to see you. And Mike Keys from the Dorsey firm is here with us too. Hello, Mike.
Hello, Denise, and hello, Emory. Great to be with both of you, as always.
Yes, great to see you both. We are going to get right into it. Lots of interesting stuff going on, stuff that we don't actually have a guest other than we hosts today. But actually, I'm pretty excited for us to have a discussion of things that aren't skewed toward a particular guest, but are things that we've been monitoring over the last few weeks and perhaps haven't had the chance to get to, or things that have come up recently that we're just all interested in. So that's what we're going to be covering today, and we're going to start with a case that involves trademark. So if you've been watching the show religiously, as I hope that you do, we have followed the Simon Tam slants case since it has originated. Right now, it is positioned to potentially go before the United States Supreme Court. And it involves the reappropriation of a racial slur. If you haven't been following the show religiously, the Slants are a band out of Oregon. They're really quite good. We've had their lawyer, Ron Coleman, on the show before, although because of the posture of the case, he couldn't substantively discuss the case with us. And it's a fascinating case. It involves whether the Slants can register a federal trademark in their name. They have had some issues with that because of the scurrilous nature of the racial slur implied by the name the Slants. So their case is about to go up to the United States Supreme Court if the Supreme Court decides to take it, to give us a definitive decision on this, because the federal circuit has gone one way and the USPTO has decided that maybe the Supreme Court should get involved at this juncture. Now, this case is not just interesting from the standpoint of the Slants and folks like them who might be a minority group who would like to embrace a racial slur for ironic or political commentary kind of reasons. This case is also relevant to entities like the Washington Redskins, who have had a lot of flack in recent years about their trademarked name as well. So what has happened recently, the Redskins have their own dispute, trademark dispute about their name that's pending. But rather than wait in line to get in front of the Supreme Court themselves, which they would like to do as well, they have recently filed a brief in the slants petition, saying, among other things, that they think with their high-powered team of lawyers that they can really argue and flesh out these issues better for the Supreme Court. So, Mike, I know you follow this case closely and the procedural developments here. What did you think about the Redskins' latest maneuver?
Yeah, I thought there was some delicious irony associated with the Redskins filing that brief with the Supreme Court, not the least of which is the lawyer that's representing the lead lawyer for the slants, as you mentioned, and as we've had on the show before, Ron Coleman, was successful before the full federal circuit en banc in having that court rule that the Lanham Act, Section 2A, was unconstitutional. Did a great job, argued the case very well, ultimately got a great opinion out of the federal circuit for his client. On the other hand, the Redskins so far are 0-2. They lost at the PTO. They lost before the Eastern District of Virginia, yet they're arguing to the Supreme Court that the Redskins and their legal team are the only ones that have sufficient knowledge and sufficient expertise to argue the case before the U.S. Supreme Court. So I thought, just given the their status, their record thus far before both the federal agency and the district court, I thought it was interesting that they thought that they are the better candidates to argue the case.
Yeah, and if you look at the actual parties, I mean, you couldn't have more night and day differences. Mark Randazzo, who was on last week or the week before that, actually had commented to, I'm not sure if it's Deadspin or Above the Red Line, but if they were really concerned about winning the overall issue, they would withdraw, because on the one hand, you've got these kids that are, a punk band trying to reclaim this racial slur for civil liberties, long, proud tradition of civil liberties strategy. And on the other hand, you've got the Redskins. And it's, one is a very sympathetic plaintiff and the other is very much not. So it's a lot of sweet irony here.
Right. He had a great comment along the lines of the Redskins may as well argue that they could rename themselves and that would be okay too. And if you go through some of the Redskins filings in their own case, they have taken this tack of trying to pull out every offensive trademark associated with a porn site or, some sort of dodgy, underhanded, borderline legal, certainly scurrilous site out there that has managed to get themselves a trademark. And they're attempting, what they're attempting to argue is if you'll grant marks to the likes of these, then certainly our mark doesn't have any issues. But what it comes across as is, hey, we're just as good as porn.com or whatever. I mean, it's pretty funny, the list of names that they've submitted for consideration. Mike, what do you think of that strategy?
Yeah, I don't know. I mean, it's not, I'd rather be on the side of the slants than on the side of the football team for sure, in terms of the optics of the argument. The other thing that seemed to me to be an inappropriate pot shot here is that the Redskins lawyer argued in the brief to the Supreme Court that, look, the briefing that was submitted by Ron Coleman and his team didn't even meet the page, didn't exceed or meet the page limitation, as if that's a signal of poor lawyering. Quite the opposite. If you can make your case and explain for the court in less than the page limitation why you should win, so much the better, right? We don't need to have excessive writing on the issue. So, just another, I think, probably inappropriate thing that, for my money, didn't seem very persuasive at all. Quite the contrary.
Is this an unusual thing for the USPTO to want the Supreme Court to get involved? They're the ones who have invoked the Supreme Court here in the slants proceeding.
Yeah, I mean, I don't necessarily think it's that uncommon. I mean, I think the PTO feels a little bit hamstrung here. What it's been doing is, instead of rejecting applications that it finds disparaging, it's simply suspending the prosecution of them. So it's got a whole bunch of applications that are currently in purgatory, if you will, that haven't received a rejection or an approval, and they're kind of keeping those in abeyance, waiting to see how this is going to play out. So I don't find it particularly uncommon that the PTO would appeal there. After all, the only thing it can do is either abide by the Federal Circuit's decision or appeal to the Supreme Court. So it's decided, hey, we need to get this clarified as to whether Section 2A is truly unconstitutional, as the Federal Circuit tells us.
Right. I'm curious as to whether you guys think, I mean, there are obviously ways in which these marks are similar, and there are ways in which they're different too. We have no reappropriation by the racial group in question on the part of the Redskins. They simply were able to get a mark decades ago, whenever that may have been, and now have a strong commercial interest in it. If they had applied today, they might not have gotten the mark, as we can see from what the slants are going through. So I'm wondering if you think, if both of you think it makes a difference whether you are a member of the racial group whose mark you're, racial slur you're trying to reappropriate and repurpose. And if also what you think about the fact that the slants are now applying for their mark, but the Redskins have had theirs for a long time. They're sort of grandfathered in, perhaps, under a standard of granting marks that might not still be used by those making those decisions. Mike, what do you think?
Yeah, I really do think it makes a difference that Simon and his bandmates are all Asian. You know, as Simon has mentioned, and we actually had Simon and his bandmates up to Dorsey in Seattle and put on a CLE about the case. Fun little twist. We actually had them perform after the CLE.
Oh, that's
we had
awesome.
a blast. Yeah, it was a lot of fun. Had a lot of people say this is the best CLE I've ever been to. So
yeah, bring it down
by
to
the
San
way,
Diego, please.
if people are interested, you can replay it at our blog, the tmca.com. There's the video link to it. So, but in any event, as Simon said, both at the CLE and has said in some of his TED Talks and otherwise, that the reason his application was rejected is he was too Asian to have the name Slants, is how he puts it. In other words, if an all-white band would have applied for the name the Slants, probably would have sailed through. But because Simon and his bandmates had Asian imagery associated with the application, and they're obviously all American Asian, that is the precise reason why the PTO ultimately found that this would be disparaging, because it's being used by members of the Asian community, and other members of the Asian community may find that to be offensive. So I think that's a pretty compelling argument when you contrast that to what the Redskins are saying, which I guess the argument is, or at least one of them is, we've been doing this for a long time. You know, we should just keep the registrations on the books here. We've been using the name for 70 years, and therefore we're entitled to keep our registrations. I know that's not all of the argument, but you know, that's certainly one pillar of the argument that they're making. So
are you saying that?
How about you?
I guess I'm showing my inexperience here, but I'm not sure if I understand everything. Are you saying that because the Redskins have had their trademark for so long, had the Redskins applied for the trademark Redskins today, you think that it would have been denied?
That's my guess, based on what the slants are going through.
Right. Because, I mean, they're essentially on the same side of things. The Redskins, I mean, as far as I think that the difference here is, like what you were saying, that the optics of the case are very distinct. You know, the Redskins are not very sympathetic at all, while the slants obviously are. But as far as I can see, it sounds like I leaned more towards the idea that having forbidding disparaging remarks in a trademark is unconstitutional, and I find the Emory Tam's First Amendment arguments convincing. But I guess the more I look at the Redskins case, I'm not really sure what they're arguing, because it seems like their trademark already runs afoul of the law.
Right, but does the USPTO have an obligation, if it granted trademarks in the past, to go through and review them and say, oh, we granted you that, in the 1960s, but we wouldn't have done it today, so we're going to revoke it. I don't know that it has that practice in place. And I think that the reason the Redskins mark is up now is because of challenges that have come from outside. Am I getting that right, Mike?
Yeah, I think that's basically right. That what they're saying is, this is ultimately, this case has actually been going on for 20 years or close to it. Mm-hmm. So this has been up and back between the PTO and the DC circuit, I believe, a couple of times. So I know this reaches back into the 1990s when these arguments were first being made. So yeah, I think essentially what the argument is that, look, today it's disparaging, and it would be disparaging to a substantial composite of the Native American community. And, you don't look at that necessarily from the perspective as to when it was, the mark was first adopted and used under the statute. If it would be disparaging, presumably at any time, it would be subject to cancellation. So even though some of these marks have been on the books for decades, that doesn't mean, at least given the challenge that's at issue here, that doesn't mean that they're immune from challenge.
Do you have to go through a review process every time you renew a trademark? Or if you have it, is it just sort of rubber stamped when you pay the fee?
Now, once you get it, you pretty much get to renew it, pay the fee. You do have to, between the 5th and the 6th year, as I recall, you have to submit a Section 8 and 15 affidavit, which allows you to claim that your mark is entitled to incontestable status, meaning that it can no longer be challenged on some grounds, which would be that it's descriptive or that you're not the owner of the mark. But I don't believe that the disparaging provision, Section 2A of the Lanham Act, comes into play even with incontestable marks.
Mm-hmm. How about the point that the Redskins make, that it seems like the USPTO is known to grant other disparaging marks, even not 20 or 30 years ago? Is that just because it's not a perfect system, and one examiner might treat things one way while another one treats it differently? How does that happen?
Yeah, I mean, each case is different, right? I mean, you come before the PTO, you get an initial examination done by an examiner. Sometimes it goes through because the examiner doesn't catch it. Maybe there's no evidence presented in the record to the examiner that this would be disparaging. And it goes through, and ultimately it, without the adversarial process kicking in, it's ultimately going to issue. So yeah, it may have happened before in the past, but again, I'm not necessarily sure how persuasive that argument is when the facts of the case here, at least I think there's substantial evidence in the record that, look, a very significant composite of the Native American community finds this mark disparaging. So to the extent that Section 2A is held to be constitutional, then it seems as though the folks that are challenging the mark here have some pretty good arguments on their side.
Right. It's worth just sort of delving into some of the things that the Redskins have argued, and the company that they're putting themselves in by saying, hey, these marks are okay, so ours should be too. They argue the PTO has registered hundreds, if not thousands, of marks that the team believes are racist or misogynistic, vulgar, or otherwise offensive. By way of example only, the following marks are registered today: Take Yo Off clothing, Dangerous shirts, Seeker dating services, Swag clothing, Blonde beer, Girl cartoons, Baked by bakery goods, Big Blend coffee, Wikipedia website, Man condoms and inflatable sex dolls, and underwear. These are not
maybe
isolated.
They were just really, really wanted to be able to argue that in court. Maybe that's the whole reason why they're filing this ridiculous brief, is they just really wanted to be able to say those things out loud in court. And I can understand that.
You think so?
Frankly.
It's just the associates at these big firms who have said, now we have the chance to
exactly
put all this stuff in evidence before a court. Well, and it bears mentioning too, for our purposes, that a lot of where the Redskins are drawing their material comes from the online world. That's where you really find a lot of the marks that have been granted in these sort of dodgy ways. What were you going to say, Emory?
Oh, that was Mike, actually.
Yeah, what I was going to say is that recall that under Section 2A of the Lanham Act, there's the part dealing with disparaging marks, which would be disparaging to a particular minority. But then there's also the offensive language as well. So there's really two different types of marks that would fall within a Section 2A rejection. A lot of those that you just rattled off, Denise, those would be more not that they're particularly disparaging, although a couple of them were, but sounded like most of those would be considered potentially offensive.
Mm-hmm.
So
to
the extent
either way,
either way, I mean, like they're trying to make the point that, look, there's this whole host of marks out there that are on the registration that are either offensive and or disparaging, and therefore why not allow our offensive and disparaging name to remain on the books as well?
Right. And if you just haven't gotten your fill of how many registered trademarks are out there that the Redskins are arguing are offensive in this way, you can head on over to Deadspin. Barry Pacheski has a piece there. We'll put it in our discussion points for today, which you can find at tagpacker.com/user/ let's see, how did we do this? Yes, This Week in Law, not TWiL, /user/ This Week in Law is where all of our discussion points for today will reside once the show is done. Any final thoughts on? Yeah, go ahead.
I'd like to ask our resident trademark expert. I mean, obviously, I think I'm flip-flopping on this issue because, to be honest, both sides are pretty convincing. I'd like to hear what you think, Mike, just your over-under on whether the disparaging and offensive requirements are good. Is that something that we should have? Do you think that that's serving the policy interests? It seems like it might be a little, I don't know, archaic in 2016.
Yeah, Emory, quite honestly, I've gone back and forth on this myself quite a bit. I definitely am sympathetic to Simon Tam's position that he shouldn't be denied trademark rights because he's trying to appropriate what has historically been a racial slur. They want to take that back. They want to use it as a source of empowerment. And in doing so, they want to use it in commerce. They want to have a trademark because, of course, if you get a federally registered trademark, you have benefits associated with that federal registration. So I understand and completely am sympathetic and understand that. And I think he makes an absolutely compelling argument that at least either as applied or facially, this statute can't stand, or at least he's been denied his constitutional right. On the other hand, I do find it potentially problematic that we could get all sorts of applications for disparaging and offensive marks, dealing with Nazi swastikas and all sorts of other terrible racial epithets and racial sentiments that, it's troublesome to think that somebody could get a federal registration for something that would be very offensive and hurtful to a large composite of the U.S. population. So, I think
is that the purpose of trademark law, though? I mean, I always understood trademark law as, the primary purpose was to avoid consumer confusion. I would think that consumers aren't going to be confused if they see an offensive term. They'll just know, okay, well, I either do or definitely do not want to purchase this product.
I mean, certainly guarding against consumer confusion is one of the primary reasons we have the Lanham Act. I would agree with that. But in the same breath, though, I think we've got to recognize that the Lanham Act does bestow on trademark applicants certain rights. If you're ultimately able to obtain a registration, you get superior rights vis-a-vis other third parties out there, and you get certain benefits. You get to invoke customs and get counterfeit products seized or otherwise notified of counterfeit products when they hit our borders. So there's all sorts of benefits associated with it, and it's potentially problematic that we're going to allow other disparaging, hurtful comments to be registered as trademarks that somebody can then use in a commercial context. So, yeah, I understand and completely, like I said, I sympathize with Simon's argument. Ultimately, for me, I think it's the benefits of Simon's position outweigh the detriments, but I think reasonable minds can potentially differ on this very important issue.
Yeah, absolutely.
Well, that's the rub, isn't it? I think we live in such an interesting time for trademark examiners to be making these decisions and trying to decide what's disparaging and what's offensive. Because on the one hand, if you listen to, for example, our guest Mark Randazza, who Emory mentioned, we live in a time, or if you listen to a lot of politicians who are stumping in the presidential election right now, we live in a time when there's too much political correctness, when people are too careful about what is acceptable to say, and you're allowed to have evil or racist or otherwise controversial thoughts, as long as you're not using them in an illegal way in the privacy of your own home or speech. That sort of thing should be okay in our country, argue those folks. And on the other hand, we live in this time where, I don't know about you guys, but I have a young child in the house, and it's absolutely stark to me, the contrast between what I was exposed to by media as a child and what he is exposed to, simply by virtue of the fact that he watches a lot of stuff on YouTube. And even though that there's, some filtering and control that goes on there, it's pretty much the Wild West, and language and course topics are very, very common. So on the one hand, people think that we're too restrictive. On the other hand, I would argue that our sensitivity level is being lessened to things like bad language, et cetera, because the FCC doesn't govern the internet. On the internet, you can pretty much say what you want. So
South Park used to be risque.
Right, exactly. It did. And I'm sure, over the years, as I've tuned into more current episodes of South Park, it seems like they are trying to push the envelope harder just to stay relevant. That some of the early seasons seem kind of quaint and cute now because they were not quite so outrageous. So, against that backdrop, I don't know that I'd want to be making that decision where reasonable minds could differ, whether it's disparaging or offensive or not, but somebody's got to make it. We have a comment and a question from chat that we should address before we move on here. The question, and I'll put this to Mike, is whether in this whole calculus of deciding whether a trademark is disparaging, whether the USPTO actually goes to the groups potentially disparaged and does any sort of research or opinion taking, or tries to make that judgment call on their own.
Yeah, it's a great question. In this particular case, my understanding is that Simon and his team actually commissioned a survey to be done and actually presented that evidence to the PTO. I can't recall exactly what happened with it, if the Trademark Trial and Appeal Board found it not persuasive or what have you. But yes, typically how you would establish this is how you would establish it in a court of law. You could do it through affidavit testimony of individuals that are members of that particular segment of society. you could do it through a more scientific method, which would be through a consumer survey study of some sort. So, yes, I believe that evidence was, well, I know it was developed by Simon Tam and his legal team. I'm not sure what the PTO did, if it rejected it or if it looked at some countervailing evidence. But yes, that would certainly be a way in which you would do this. You would present either, like I said, survey evidence or affidavit testimony.
Right. So that great question was from Reverb Mike in chat. And then Chumley in chat has been cracking me up with various comments. But one is that Redskins isn't offensive. No one person has turned the screws on the Browns yet, which just sort of goes to your point earlier, Mike, that if the Browns were an all African American team and were to seek registration of that mark today, they might run into the being too black problem that Simon Tam says he faced in being too Asian in trying to get that mark. Okay,
that's right. Although I will say this, I mean, I'm not a pro football historian by any means, but my understanding is the Browns were named after the coach, Paul Brown, who I think was one of the initial coaches of the Browns and is kind of very famous in Ohio football lore.
Oh, absolutely. I didn't think that it was a skin color reference, or at least I hoped like crazy it wasn't. All right. Let us thank our first sponsor for this episode of This Week in Law, and that is Braintree. Code for easy mobile payments. Maybe you're working on the next Uber, Airbnb, or GitHub. Then why not use the same simple payment solution that helped them become what they are today? Braintree makes mobile payments so fast, easy, and seamless, it's almost magical. Add it to your app with just a few lines of code, and you're instantly ready to accept Apple Pay, Android Pay, PayPal, Venmo, credit cards, even Bitcoin. And if some other way to pay comes along, Braintree is going to support that too. You can bet on it. Braintree's fast payouts and continuous support mean you'll always be ready, whether you're earning your first dollar or your billionth. See fewer abandoned carts and more sales with Braintree's best-in-class mobile checkout experience. Braintree gives you a full-stack payment solution, support for all payment types your customers might want, single integration across all platforms with superior fraud protection, customer service, and fast payouts. You should check it out for yourself. Please do visit BraintreePayments.com/TWiL. Thank you so much, Braintree, for your support of This Week in Law. All right, let's move from trademark over to the social web and consider a case that, again, we discussed recently on the show, but what we did not discuss was the ramifications that the case may have for websites under Section 230 of the Communications Decency Act. So when we had Mark Randazza on the show, we were discussing his efforts in shutting down revenge porn sites like Kevin Bollert's. I forget which one he had exactly. It wasn't Is Anyone Down? It was You Got Posted, right? That was the one?
Yeah.
Yeah. So anyway, he was convicted for having that site. The unique aspect of his site was not only allowing people to post photos of the, compromising photos of people that they knew or that they had come into their possession, but having a companion site where for a certain fee, you could have those photos taken down. So all of that went very wrong for Mr. Bollert in a criminal way. He was convicted and now has been sentenced in California to 18 years. And there's an appeal underway from that sentence. And so a California appellate court is going to review and see if liability was properly imposed and if the sentence is appropriate to what happened here. And a lot of their arguments on appeal involve if Mr. Bollert is going to be held liable in this way, then other websites who look to Section 230 of the Communications Decency Act to protect them from acts of their users are in jeopardy as well. Can you tell us more about this, Emory?
Yeah, sure. So Section 230 of the Communications Decency Act is super important for the for the internet. Sure, any of our listeners probably already know this, but it basically prevents any provider of a platform or user of a platform to be imputed with the comments or acts of another user. And so essentially, this case is really sort of weedy. On Mike Masnick's article on TechDirt, I highly recommend everyone check out. And then you might actually also want to check out the comments because there are some good points there as well. But essentially, just like Denise said, this Bollier had a website that was just basically ripped straight from the style of Is Anybody Down or any of the other awful revenge porn websites. And then he had a separate seemingly unrelated website. There's not clear how much clear connection there was between the two websites, whether it was clear that they were related. But yeah, on the one side, he had the website which encouraged users to post revenge porn pictures. And then he had the separate website that said that, we have a direct line to this other company and we can get your pictures taken down for a fee. So when we're talking, to unpack this, it's his appeal. And I think that, Mike brings up a great point that, first of all, his attorneys put forth a much better argument than the state. And that, they very cleverly and, correctly cited to CDA 230. And on the other hand, the state is not really is trying to analogize it to the roommates.com ruling, which I don't think is really clear. So the roommates.com ruling was saying that roommates was not immune to because of Section 230, because on their website they had a drop-down menu that effectively allowed users to directly choose to violate the fair housing laws by selecting what kind of roommate they would prefer. Here, it's not really clear that the website that encouraged revenge porn was doing the same kind of act. It is really fundamentally different. Sorry, I keep forgetting the guy's name. Bollier's attorneys are saying that there's a difference between extortion and what he's doing here. Simply by having two websites, the existence of a third-party website is not the same as actively encouraging people and saying, okay, well, we're going to keep these pictures up unless you give us money. I don't really find that argument very convincing. And I think also that some of the commenters brought up a great point that what is different here in particular is that Bollier is I'm sorry, to rewind, at the heart of this issue is whether or not Bollier's website can be considered a platform or a content provider. Because if it's a platform, then he's immune because of CDA 230. If he's a content provider, then he's not immune because he has direct editorial control. So what the commenters have brought up in this article that is very important is that it looks like Bollier actually had direct control and a lot of control over the content posted. He apparently had the veto choosing power over when a picture went up. He also required that users connect pictures with Facebook information or some kind of, information to tag the individual, and he did fact checking on it, from what I understand. So, the article itself, Mike's article, brings up a great point that this brings up a lot of issues around CDA 230. I think that there might be some facts in this case that rule out CDA 230 immunity because it looks like he has some kind of editorial control. But yes, it's, the underlying point of Mike's article is that CDA 230 is hugely important, and that while this guy is clearly a creep and a scumball, it's important to pay very close attention whenever, rulings come out that may, chip away at 230 because so much of the web depends on it.
Right. And I think as far as I'm concerned, and I haven't delved too deeply into the parties' arguments and briefs or anything here, but it does seem to me just at first blush that the government in responding to Kevin Bollier's appellate arguments has a good point that while the analogy to roommates.com is not perfect, the point of the analysis is to see how involved the website operator is in the content that's going up on the site. And if you're going to require users to post personally identifying information about a photo, because that makes it all the more salacious and helps your companion site that is basically extortion carry out its business, then that's controlling the user content on your site, I think, to a pretty great degree. That's not just standing back and letting people post. It's imposing requirements that smack me as editorial. But
right,
you know, I could just be shaded in my analysis here because I'm not a fan of what the site was up to. What do you think, Mike?
Yeah, I mean, it seems to me, I don't know a whole lot about the case, but it seems to me like he exercised a fair amount of control just based on the Tech Dirt article and some of the other things I've read. So if you've exercised some control over the content on the site, it seems to me like 230 goes out the window. So I don't know. The thing that struck me is, I mean, the guy got sentenced to 18 years. I mean, this guy's a miscreant for sure. And totally appropriate that he should be doing time for this racket that he was running. But boy, 18 years, that sounds pretty that's a pretty hefty sentence given what was involved here, as bad as it was. So I don't know. Interesting to see what happens.
It's a very weedy issue. Absolutely. I'm right there with you. Clearly a scumball, definitely deserves jail time. 18 years. It's tough to say. But I think that what I think was Mike's point was that, or part of Mike's point that I think is salient is that, you know, the state didn't argue sufficiently. You know, the Bildier's attorneys are saying, look, Section 230 applies. He's not a content provider. He's a platform, and the state hasn't sufficiently argued that or shown that he is. And I think that's the underlying issue.
Right. So it sounds like, you know, our best guess on where this is going to go, and we'll continue to follow it as it wends its way through the California appellate process, is doubtful the liability will be challenged, but possibly the sentencing seems extreme and could be adjusted downward. What were you going to say, Mike?
Yeah. So Emory, do you know whose burden would this be? Would this be the prosecution's burden to show that he doesn't fall within Section 230, or was it his burden to show that he's somehow immune? It would seem to me it would be his burden, right?
I think case law has shown that it's been their burden to show that they are a platform and not a content provider. Yeah, that's a very good point.
So, yes, for those of you who are not lawyers, who has to prove something is often very important in the outcome of a case. And if it's a close question and you've failed to meet your proof, then you're just not going to get the benefit of that argument. Let's make scumball sentencing our first MCLE passphrase for this episode of This Week in Law. We put these phrases into the show because we are providing interesting, insightful, educational outlooks on current and existing law. So you may as well, if you would like, if you're a fan of the show and a lawyer or another professional who would like to receive professional credit, you may as well take a shot at getting that credit through listening to the show. And if you'd like to do that, you can go to wiki.twit.tv, find This Week in Law there. And we've got a list of, at least for lawyers, the various forms and things that might prove helpful to you if you are hoping to apply for MCLE for listening to or watching the show. And we put these phrases in so that you can show that you actually did that if your oversight board would like to see that kind of proof. Let us move on and talk about a case we've been following since 2011, the Redigi case, which has to do with whether or not digital files can be resold. So this case against Redigi, which had a business model of providing a platform where people could resell the iTunes music that they had quote unquote purchased, has been going on for almost 6 years now. Back in 2011, the lawsuit by Capitol Records was filed against Redigi for infringing on that company's copyrights. And Redigi lost that case. There was a judgment against Redigi in 2013. The court found that Redigi was not eligible for the first sale doctrine. And this is really the first case that brought to the fore this notion that when you're buying things like movies and music through the services that stream them, that might not mean the same thing based on the terms of service that apply, as if, back in the olden days, if you guys remember going down to Tower Records and picking up a piece of physical media and bringing it home with you, that your rights might actually be different. So Redigi and Capitol Records have actually been involved in this case since it was filed in 2011, and there was the possibility of a second trial, but it seems that last month the parties have reached an agreement where the case is not going to go to trial again. There is a stipulated judgment against Redigi that will be entered. There's no information as to what sort of financial compensation might be flowing from Redigi to Capitol Records. There was a large judgment against them in the first trial. So, Mike, I think you flagged this maybe in your Twitter feed, and so let's get your take on this first.
Yes, so this is a really interesting issue, as you mentioned, Denise, involving first sales. So Section 109 of the Copyright Act provides that once you obtain lawfully, and that's the key here, once the copyright owner puts a book or a CD or some work into the stream of commerce, and you lawfully acquire that copy, you are then, as the owner of that copy, you can dispose of it as you wish. You can give it to your friends, you can resell it, you can rent it, you can do all sorts of things with that copy now that you lawfully own it. So what Redigi wanted to do is it had the business model of saying, hey, if I can resell a CD or a record, why shouldn't I be able to set up a business model where I can provide a platform whereby people can sell their digital music or digital files? And what Redigi did is, through its platform, what it would allow a user to do is it would allow a user to take its digital library, and it had this piece of software that the user would download. It would scan the user's hard drive and look for lawfully purchased copies of your Apple iTunes library or songs from the library. And then what it would do is it would take that copy, your digital copy residing on your hard drive, and it would upload it to the Redigi cloud, and then it would delete it from your hard drive. So you no longer had a copy of it, and it would be able to be sold or otherwise transferred to some other user. So Redigi's argument all along was, look, this is really no different than me disposing of my CD or my record that I purchased, because I lawfully obtained a digital file from Apple. I'm disposing of that, and I'm no longer enjoying the benefits of having that copy on my hard drive. So I should be able to invoke Section 109 of the Copyright Act, saying this is essentially, in modern day parlance, a resale of my digital copy. And the court ultimately said, no, that's not true, because Section 109 or the Copyright Act itself tells us that downstream user that purchased that work through the Redigi platform ultimately makes another copy of that in order to listen to that particular work. And that copy that's being made by the Redigi service was not authorized by the copyright owner, and therefore you lose. You lose under Section 109, and you also lose under Section 107, the fair use doctrine, which was also rejected by the court. So my understanding is that the case there has been this stipulated judgment, but it's also, I don't know if it's being stayed or being held in abeyance somehow, but my understanding is also that this case is on its way to the Second Circuit to ultimately decide the issue of liability, decide this exact issue under Section 109. Can this be eligible for first sale immunity?
This is really a big deal, I think, because of the way consumer expectations evolve around purchasing digital media. I think it would come as a great surprise to most lay people when they've shelled out a bunch of money to purchase movies or music, to think that they don't have rights in that, that they could not financially make use of reselling them or having an heir resell them should they pass away. And the way things stand now and the way Redigi organized its business, that doesn't work. And you were interviewed for this piece at a Journal of Musical Things, Mike, and noted that the court found the first sale doctrine didn't apply to the works at issue because once the files were uploaded to Redigi's cloud storage, that constituted a new reproduction, as you just said. But is there a way, can you conceive of a way, sort of a la the Aereo case, where a creative company could figure out a way to have you transfer the files on your hard drive without there being a reproduction and thus get around that problem?
I don't know. I don't know the answer to that, Denise. It seems to me that right now that may not be technologically possible or feasible because there's always going to have to be another copy that's being made by the end user in order to listen to the file, I would think. Mm-hmm. I don't know. Maybe there would be a way to stream it from the original purchaser's website. But then even then, if you're streaming it, that's probably going to constitute some sort of improper performance in violation of the terms of service or maybe even under the Copyright Act. So I don't know. It seems like as we understand things right now, that might be difficult.
Well, I don't necessarily, I'm just sort of conducting a thought experiment here. I'm not saying it would be a good business model, but I think it should be somehow technologically possible to take bit for bit the copy of the file that is on one computer and transfer that to another computer, the same way you would stick it on a USB drive, although maybe that, again, is just making a copy and not actually deleting it.
I think it goes back to The Prestige. That was the movie, right? The Prestige with the body swapping. But this is that I didn't find that portion of the court's argument very convincing at all. That whenever you are moving a file on your hard drive, if you want to move it from your My Documents folder to your My Pictures folder, you're making a copy. It's deleting the original and it's copying those bits over to a separate sector of the hard drive. So like the idea that that transferring the song to this server is in fact making a separate copy of it and for that reason runs afoul. I didn't find that very convincing. What I did think was, so first of all, I loved the idea of Redigi. I think that, it was very, very clever of them to search for songs that were legally purchased. It was them saying, okay, well, the first sale doctrine exists. How can we apply this to the internet? The best way we can think of doing this is to search for songs that have been purchased, so we can rely on iTunes to prove that these people have actually purchased the song. The problem, though, is that they're not purchasing the song, they're purchasing a license to the song. So that's where I think that the problem comes in here, is because when our conception of what's happening when we're buying this media is, incorrect. We're not buying the media, we're buying permission to play the media or to download the media from this other person. That being said, like I said, I love the idea of Redigi. And, on the technical limitations that we were just talking about, we had Greg McMullen of Ascribe on the show a couple of months ago, but they're doing something that's trying to do something similar to this. So like we were saying, technically, it may be impossible to transfer a song without copying it because whenever you're moving these bits around, it's just copying and deleting. That's all it is. But what Ascribe and the folks over there are doing, they're trying to create cryptographic tokens that you could then pair with pieces of media so that individuals that were then, signed or recorded on the blockchain. So what that would let people do is release cryptographically authenticated individual copies of things onto the internet, so that you could know that this file is one of a limited run of releases on the internet, and I could then know that if I transferred the cryptographic token assigned to that file and the file to someone else, that person would be the person that has the proof that they own it individually. It's not quite DRM because it's not software preventing the playing of the file, but it is a sort of cryptographic proof that the purchase was transferred. So I could see a platform like that enabling a sort of first sale doctrine on the internet. But yeah, right now, technically, it's just not possible.
Well, Emory, so how is that model, though, different? How does that alleviate the redigi issue about another copy being made by the end user or somebody else that wasn't authorized?
It doesn't alleviate. All right. So the problem with that is that in the redigi context, it wouldn't alleviate the problem specifically here because, again, it's scanning things that were purchased from iTunes. But the idea being that if you had an iTunes that worked with a scribe, or if you had, a platform that allowed people to sell music or sell digital goods that also came with that also accompanied the sale a cryptographically unique token, then that person that then purchases from that service wouldn't be purchasing a license. It provided that the terms of the purchase were different, that the contract allowed them to actually be buying the thing and not a license to the thing, then they would have the ability to cryptographically prove ownership, allowing them to transfer that ownership to someone else without the possibility that that individual thing could be copied and exist on both computers simultaneously. Is that clear? I feel like it's a little unclear, but
no, I think that's clear. It seems to me, though, that a system like that would require interfacing with Apple, right, to get that system fully up and running and operational? Or is that something that can be done independent of Apple? Because if it's going to require Apple's consent, I mean, Apple will have absolutely no interest whatsoever, nor will any of the record labels have any interest in this, because of course it's just going to significantly reduce revenue that Apple would otherwise receive from the purchase of a copy from iTunes, I would imagine.
Well, actually, that's interesting. I mean, on the one hand, so Ascribe is the organization is working with Creative Commons, and you can sort of see it as similar analogies to Creative Commons from the beginning. Why would any artist want to license their work under Creative Commons? Because it would seem like that would automatically always mean that they would be losing revenue. But that's not necessarily the case. We've seen that, licensing your work under CC can enable more people to see your work, can sometimes get you into new markets, can, let you have finer control over how that work is shared, while still allowing some people to use the work without paying you licensing it. Transferring that model to Ascribe, what they're imagining is that this could be partnered with so for example, they have Creative Commons licenses that are sort of working with Ascribe already, where the cryptographic token is tied to some kind of smart contract language that allows for the specific kind of use. So whether Apple, it would have to be sort of plugged into Apple, or Apple would have to adopt this kind of service, but that doesn't mean that Apple has to be the service that does this. It could be another service that comes up and allows this. And it doesn't mean that Apple would not be able to do this should it show that it's successful elsewhere. But technically it is something that's not capable of being done right now with Apple, but it is something that could be done in the future using blockchain technology. Right. But it would require some kind of cooperation, at least minimally.
Mm-hmm. So I'm gathering two things from this discussion. Number one, that, and I thought this before we started talking about it, that the terms of service for things that people are quote unquote purchasing online are way out of whack with their expectations.
Yes.
And companies are going to either have to address that or live with the fact that someone is going to come along and figure out a way to do redigi in a way that works with the for sale doctrine.
So, if we're talking about the, you remember when the Wu-Tang Clan wanted to sell an album for $1 million, because that's frankly the only way that they could create this sort of artificial exclusivity on the internet today. They have to sell this single copy for $1 million. So they're the only person that can buy it. And that's the only way they can do a limited run in 2016. Well, what this kind of technology could enable, if you have, things like a scribe or, cryptographically provable limited runs, you could have artists that make a limited run of, say, 100 copies of their album that run for, 200% of what the smaller version costs. They could. I don't believe that this kind of system automatically means, or that the redigi platform realized would automatically mean that Apple would be losing revenue automatically. I think that, it enables new business models. And I think that the first sale doctrine is really important. Logically, it makes a lot of sense for us to want to be able to sell something that we then purchase, because otherwise it's totally different from everything else that we purchase. It feels like that sort of distinction isn't really fair for a lot of people when they realize that it doesn't apply to their digital goods. But yeah, at the heart of the issue is the fact that we're not buying these things, we're licensing them. And that the terms and conditions that we're all agreeing to are really almost certainly far from what you're actually expecting it.
And of course, streaming services make this conversation irrelevant if everybody goes that route. But I think there are plenty of people remaining out there who don't necessarily want to stream everything and have good reasons to want to have digital copies on their computer of the music that they're listening to, or whatever media it might be. Anecdotally, my credit card number changed that was associated with my iTunes Music subscription this last week. And I had a huge moment of panic, wondering if, because the service shut off until I reinstated a valid credit card. And my family uses that service to make playlists. And, so even though it's a streaming service, we definitely have things that we consider important to us from an ownership standpoint that are associated with that streaming service. And so I, was just crossing my fingers that if you let it lapse, they preserve everything that you've put into the application. It seems like it all came back when I re-entered the credit card. So phew, I'm not in trouble. Yeah, course, exactly. So you're
it's not like you could put that in your will though or anything.
Right. No. Yes, put in the will. Be sure to keep making payments on the Apple Music service. And this is a huge tangent and not something we planned on talking about on the show today. But I think that is an enormous area where people are going to find themselves surprised too. And I want to get some sort of probate or estate planning person on the show to talk about what happens when someone passes away and they are the person in their household who is in charge of keeping all the subscriptions alive, whether it's the milk that gets regularly delivered to your house, you're going to get snowed under.
Our article a couple of months ago or something about a family whose husband, or a wife whose husband had died, and she had to, it was a ridiculous process of trying to prove to Apple that her husband was dead. And Apple required some kind of proof of death by the coroner or something. It was, this is not a new problem, but yeah, I agree. It's going to be a bigger one.
I think it's going to be a bigger and bigger one as time goes on and more people, just put things on autopilot. What happens when the pilot behind the autopilot goes away and you're either snowed under by, we've talked about this before on the show, too much toilet paper arriving at your house, or, services that your family relies on are just gone. All right, let us thank our second sponsor for this episode of This Week in Law, and that is TunnelBear. TunnelBear is the simple privacy app that provides you with a secure and private connection to enjoy a more open internet. TunnelBear lets you bypass all the annoying details that typically come with using a VPN for personal use. There's no need to mess around with port configurations, DNS, or other router settings. TunnelBear handles all of that in the background. It's incredibly easy to use. Just choose a country in the app, turn TunnelBear on, and watch as your bear tunnels your internet connection to your new location. It's quick and easy to get started with TunnelBear with no credit card required. When TunnelBear is turned on, your connection is secured with AES 256-bit encryption, the strongest encryption. You can bypass geo-blocking and hide your location. Your online activity is shielded from prying third parties, hackers, and other local networks. TunnelBear also prevents your internet service provider from monitoring all your online activity. They also have a top-rated privacy policy and do not log user activity. Tunnel to 20 different countries and use the internet as if you're in another country. Get your free TunnelBear now at trytunnelbear.com/TWiL. TunnelBear is the simple privacy app for mobile and desktop browsing. We want you to visit tunnelbear.com/TWiL to get your free account today. It's quick and easy at trytunnelbear.com/TWiL. Thank you so much, TunnelBear, for your support of This Week in Law. All right, we've had a couple of legislative developments that we haven't addressed recently that deserve addressing. So we're going to do that right now. The first development is the DTSA passed the Defend Trade Secrets Act, which gives us a federal trade secrets law in the United States for the first time. We had Dave Levine on the show a while back, who was the instigator, driving force behind the letter to Congress by, I think it was over 40 law professors, explaining all the reasons why the Defend Trade Secrets Act was a bad idea. And it has passed now and will impact United States law in various ways. It's even more of an impact, I think, than when the Copyright Act passed and became the federal means of pursuing copyright infringement actions, because state trade secrets acts are left alive under this new federal law. So it's just in addition to and not instead of the state laws that already govern trade secrets. So it's out there, and I think the short story is, and I encourage you to read more from Professor Levine, and also Professor Goldman has a great piece on the various ways that the Defend Trade Secret Act is what he calls the biggest IP act, is the biggest IP development in years. It seems like what we can count on for sure is seeing a lot more trade secrets litigation under this act, because trade secrets come up, as Professor Goldman points out in his piece. They come up all the time. They come up whenever someone is hired or fired. They come up whenever an employee within a company talks to the media or talks to friends. There are just all kinds of episodes in day-to-day life that can impact trade secrets when you're working for somebody else. So it's going to be an important piece of law, and litigation is no doubt going to become more common. Do you agree with all this, Mike?
Well, I agree it's a significant act. I agree it's a very, I don't know about the most important act in the last 30 years. What I don't agree with is, there's so much opposition to this, as you mentioned, the letter by the 40 law professors, including our friend Dave Levine. Mm-hmm. Now, I think the opposition is kind of a tempest in a teapot, frankly, because there's all this hue and cry about how there could be this incredible overreaching because the act provides for a plaintiff to come into court and get an ex parte seizure order and so on and so forth. But, the fact of the matter is the text of the statute that passed both the House and the Senate provides for a very rigorous showing by the plaintiff to get an ex parte seizure order. I mean, you've got to go through and establish clearly under the statute, and that's the language that's used, clearly the court's got to be convinced that you meet all of these elements, including that a standard injunction, a TRO practice or otherwise wouldn't be sufficient. And so you got to make a very significant showing in federal court in order to get this ex parte seizure order. So I think that's largely overblown, the concerns there. The other thing that I'm somewhat skeptical is a problem is this whole notion that the federal act didn't preempt individual trade secret laws, as though we're going to now create this confusing kind of dual system of trade secrets. I just, maybe that'll happen, but I'm just not convinced. I mean, take, for example, the Lanham Act. The Lanham Act provides for federal protection of trademarks and registration of trademarks, as we talked about earlier on the show today, and it provides for a cause of action under federal law for unfair competition and infringement and so on and so forth. And it in no way preempted any state law claims for trademark infringement. So I'm not convinced that there's much of a problem here. As a matter of fact, I think, federal courts are very capable and able to deal with IP issues, and trade secrets are in many ways, I think, a great place for federal jurisdiction delay. So, I think it's a good act. I think, we'll see how it all shakes out here, of course. But, I think a lot of the objections to this act are probably a little bit premature and overblown.
Yep, we're just going to have to see how this one shakes out. But I did want to let people know, since we had Professor Levine on the show recently, and there was some chance still that their opposition might prevail, it did not, and the act passed. Another thing that looks like it should pass is something called the Email Privacy Act. This would amend the Electronic Communications Privacy Act of 1986 and make it harder for the government to get to things like your private email. It passed Congress by a staggering 419-0, the House part of Congress, and now must go on to the Senate. However, there's no guarantee that it's going to pass there, despite its really, really strong support in the House. The SEC and Senator Chuck Grassley are thinking that it is a bad idea and that it's going to hinder law enforcement. Emory, what do you think about it?
Yeah, I mean, I don't really have much more to add outside of what you and Mike said on his article. Apparently the SEC and the IRS is especially interested in making sure that they can continue to look through your emails without a warrant. Where everyone knows where I stand on the issue, frankly, when people come up saying, whenever I hear anyone arguing that we need less protections for privacy or that, we need to make it easier to get warrantless searches, I'm just immediately red flagging them as Sith. So that's where I'm on the issue. I think it's great. How rarely do we get unanimous passing in the House? That is just such a bizarre situation, and it's something that is so clearly, yes, our emails. Yes, a warrant would be great. You want to look at my emails? That's fine. Get a warrant. Why would anyone not want a warrant process to look at our private communications?
Right. It does really seem like the Electronic Communications Privacy Act did not anticipate well enough the world that we live in today. It was enacted in 1986, after all. And,
even then, the ECPA has been, people have been trying to reform that since it passed, So.
All right, we'll continue to keep an eye on that one and keep you guys posted. Right now, we're going to move to another topic that really, since I can't really identify the law and policy ramifications of it, but I just sort of intuitively feel like they're there. I want to put this to Emory and get his take on it, but I haven't really been able to classify it yet, so we're going to talk about it under our ambiguous other category.
So our listeners here, this is an audio podcast for many people. I know I never actually watched the video until I started co-hosting the show, but really, audio listeners, you might want to go ahead to our website. Just check out that bumper. It's just so perfect. It is so great. It's so dramatic.
It's so dramatic for such a mundane word. Yes. So what I've slotted under other here today is this whole brouhaha about this gentleman who has come out and said he is Satoshi Nakamoto, the creator of Bitcoin. His name is Craig Wright. He's an Australian entrepreneur. But there is, of course, as there was bound to be much doubt and controversy over this claim.
Yes.
So am I right in intuiting that we should be paying attention to this, Emory?
I mean, that's actually a very good question, and I think that if you look to the Bitcoin core community, I think most people, the prevailing thought is that no, this is not something that we need to be paying attention to.
Okay, forget it.
The Satoshi Nakamoto was a brilliant person, individual, group of people, whoever. The fact is that he created something incredible that works, and then he voluntarily backed away from the project. The underlying project itself is still working great. It's still being developed. There's still a community of people behind it. Why do we need to unmask the creator? This is, the whole crux of the project is to create this peer-to-peer economy. The idea that this is almost like a new nation or a new government. It's totally peer-to-peer, ad hoc, and the way this works is that the rules that connect every peer are open source and distributed, and everyone knows them and they work perfectly. And if they don't work perfectly, then the community can develop them until they do. Satoshi Nakamoto. And on the Craig S. Wright thing, first of all, there's no debate. There's zero debate right now that Craig S. Wright is not Satoshi Nakamoto.
Okay.
This is, by the way, the second time that he's pulled this. About a month and a half ago, if people were paying attention, maybe 2 months ago. Actually, time flies when you're in law school. Several months ago, Craig Wright came out and did almost the exact same thing, that there was an expose saying that he was Satoshi Nakamoto, and it turned out that he probably had a fairly heavy hand in encouraging the publishing of that expose. Here, what happened that is really sort of interesting and controversial is that Craig Wright, convinced one of the core Bitcoin developers, Gavin Anderson, who has done a lot of work for Bitcoin, very respected in the field. He convinced him that he was Satoshi Nakamoto. So for all of our listeners that are wondering, well, how would you prove that you're this person? It's actually a very, very simple task. If you were Satoshi Nakamoto, what you would do is you would simply submit a transaction signed with the key owned by Satoshi, because we know the key that he had, they're recorded on the blockchain. So all you would have to do for absolute cryptographic objective proof would prove that you have the keys. It's a simple thing. What Craig Wright did instead was he sort of had this weird cloak and dagger process where he met with this developer, handed him a new computer that one of his associates bought and brought. That I think the prevailing assumption right now is that there was some kind of sophisticated man-in-the-middle attack done on the when he was doing proving his identity. Which we don't need to go in here. I'm sure Security Now could talk about the details of that. But
right.
This guy's a scam artist.
The only other thing I'd throw in that makes this interesting from a legal standpoint is there are many states with anti-impersonation and anti-identity theft kind of laws. And I think a law professor at minimum could have a lot of fun on an exam considering whether you might violate those laws by attempting to appropriate the identity of someone who is anonymous and may actually be a group of individuals rather than one individual.
Is it identity theft if I steal your gamer tag or your pseudonym? Probably not. But would be a good law school essay.
Yes, it gets interesting on that front. All right, thank you for the update there.
You're welcome.
We're going to leave you. We actually have managed to turn up at the end of the show here in advance of our resource and tip of the week. We're going to leave you with yet another animal selfie of the week. Now, when I've been looking online for animal selfies to put in this segment, I've been thinking dogs, cats. We recently found some wild Amazonian animals that were wandering in front of motion-activated trap cameras. But what didn't come immediately to mind, but there are a lot of them out there, are sloths. Sloths apparently lend themselves well to animal selfies. They seem, I think of them as sort of slow and lazy, but as you can see, they like to reach out and touch things. If you're watching the video, there is a bit of video of the sloth activating the camera in an adorable sort of way. So if you're a fan of animal selfies and all of the copyright ramifications that they raise, you have to now add sloths to your list of animals who might find themselves mesmerized by the camera. So thank you, Emory, for the pointer to the fact that, of course, Reddit, like it tracks so many things that are obscure and yet interesting, has a full subreddit on animal selfies. So,
I wonder if the sloth should consider filing an amicus brief in the Naruto case.
Hey, it would take too long. You'd miss the filing date.
Poor little slow sloth. All right, we have a good resource of the week for you. Emory put this in our way, and it's a great thing to check out. It's called Usable Privacy, and it is a site that is a partnership of a number of law school clinics, tech law organizations that are helping make privacy policies more understandable. So they're going through and trying to pick out as many privacy policies as they can. They're identifying the common elements that you might see in different kinds of privacy policies and what they mean. They're trying to explain them in plain English and graphically give you a frame of reference so you can go to this site, say, hey, my kids want to use, or I want to use XYZ service, but I'm concerned about the data and what might happen to it. You can go to this site and you can get a good handle without having to actually read through and try and understand the privacy policy yourself. Anything you want to add, Emory?
No, but the usable privacy, I guess, yes. And the usableprivacy.org is a really, really cool project. Their goal is sort of this combination of crowdsourcing and natural language processing, as I understand it, to sort of pair tools with people to try to map privacy policies online. So, it's taking a problem that is yet to be solved, and that is that privacy policies are incomprehensible. And even if you do understand it, you don't read them. So, and it's trying to create a technical solution to it. So I love it. Keep fighting the good fight, usable privacy. Thanks.
I think it'll be really interesting, too, to find out how many privacy policies are just the same, where people have lifted language and the same language is floating around on the net rather than actually tailored to the needs of the particular site and its users.
That would be a very, very awesome study for some law student or grad student that has a good background in statistics. Do that. That would be awesome.
Yep, please do.
And then we'll talk about it on TWiL.
We promise we will. Our tip of the week is that if you're interested in the future, all you need to do is watch The Simpsons. They'll tell you everything you need to know. This is a reference to a cool video over at All Time Tens. They're a channel on YouTube, and they have a video called 10 Inventions Predicted by The Simpsons. It's pretty long, so we're not going to play the whole thing, but I'll just point out to you that they lead with 3D created birthday cakes, which we know are a thing now. Also included is a baby language translator, which someone is trying to develop, and many, many more fun items in this video. So I recommend it. And if you're interested in the future, The Simpsons, your go-to. Any thoughts on that, Emory?
Got nothing except that Dick Tracy definitely had the watch computer transmitter before The Simpsons, but either way, I'm not getting an Apple Watch.
That's true. That's true. Anything, Mike, on our tip or resource?
No, I don't have anything.
Perfect. All right. With that, we are going to wrap up this episode of This Week in Law. We're so glad that you joined us. If we generally record, as you know, this is a pre-recorded show, but we generally record on Fridays at 11 o'clock Pacific time, 1800 UTC. We're happy if you can join us then, but don't worry if you can't. Just head on over to twit.tv/TWiL. That's where you'll find our whole archive of shows. So much goodness for you to rummage through there and enjoy at your leisure, and all various ways of enjoying the show as well, whether you are someone who just does the audio podcast, or if you like to enjoy our lovely high definition video presentations with all of the bumpers that we put together for your enjoyment as well, then choose one of the video options and watch on your phone, or watch on your TV, watch on your iPad, watch on your watch. I think you can do that. Anyway, we're just thrilled, however you can join us, that you do so. And please get in touch with us between the shows. We love hearing your thoughts on what we should discuss, who we should ask on, what your take is on the topics that we've covered. Mike is Mike at twit.tv. Emory is Emory at twit.tv. And I am, guess what, Denise at twit.tv. Find us there. Find us on Twitter. Find our Facebook page or Google Plus page if you have things that you'd like to type at greater length in public. Works a little better than Twitter for that. So however you get in touch with us, please do. Please keep watching the show. We're going to keep bringing them to you. We love doing it. It's my favorite part of the week. So I'm so glad you could join us. And until next time, please take care.